So good day everyone. Our topic for today is Introduction to Law. Well, as I know, many or most of you here ay first time maka-encounter ng law subject. So, I hope na after this session, magkaroon kayo ng at least basic understanding kung ano nga ba yung tinutukoy, kung ano ba yung sinasabi natin na law. So, let's begin. Iset muna natin yung topic outcomes. After the end of this session, you as students are expected to be able to discuss the definition of law. Palitan natin. Definition of law, either in its specific or generic or general sense. Number 2, identify the primary, pangunahin, and secondary sources of law. And third, emphasize the necessity and functions of law. Bakit nga ba mahalaga ang law and ano ba ang kasaysayan nito sa ating society? We have 5 subtopics in this discussion. First is meaning of law in general. Second, general divisions of law. Third, characteristics of law. Fourth, necessity and functions of law. And lastly, sources of law. So let us begin with the meaning of law in general. In its widest and most comprehensive sense, sa malawak daw na pagpapakahulugan, the term law means any rule of action or any system of uniformity. Pag sinabi nating rule of action, sa Tagalog, ibig sabihin yan, panuntunan ng pagkilos. It defines what should be, what should not be, what should be done, and what should not be done. Sa makatuwid, in general, law determines not only the activities of men as rational beings, but also the movements or motions of all objects of creation. So, sa malawak talagang pagpapaliwanag, hindi lang yung activities ng tao bilang rational beings, kundi, ibig sabihin ng rational being, yung being na nag-iisip, kundi pati yung movement or motions ng lahat ng bagay na na-create, whether gumagalaw or hindi gumagalaw, whether animate or inanimate. So, meron tayong dalawang general divisions ng law. First, law in the strict legal sense and law in the non-legal sense. Pag sinabi nating strict legal sense, ito yung state law. Kaya siya tinawag na state law kasi siya ay promulgated and enforced by the state. Yun namang law in the non-legal sense, kabaliktaran siya ng law in the strict legal sense. Ito yung laws na hindi pinromulgate and in-enforce ng state. Not promulgated and enforced. Una, divine law. Second, natural law. Third, moral law and physical law. I believe marami pang ibang laws na pwede nating isama sa law in the non-legal sense, pero mag-confine na lang tayo dito sa 4. Divine law, natural law, moral law, and physical law. Which is, didiscusin din naman natin as we go along. So, we go first with divine law. Divine law is the law of religion and faith, which concerns itself with the concept of sin, kasalanan, and salvation, kaligtasan. It is also called philosophical theology. Yung divine law, it differs according to what one believes to have been established and communicated to mankind by revelation. So, ano nga ba ang source ng divine law? Divine law is formally promulgated by God and revealed or divulged to mankind by means of direct revelation. Galing ito sa Diyos. So, under the Old Testament, pagdating sa Bible, divine law is embodied in the 10 Commandments. 10 utos. It is believed by Christians that these laws were formally given by God through Moses, the great Hebrew prophet and leader. So, yun ang divine law for them, for Christians. Pero, since magkakaiba nga, ang divine law, depende sa kung anong pinaniniwalaan ng tao. Pagdating sa mga Muslim, to the Mohammedans, divine law is embodied in the Muslim Quran. So, kung sa Christians, ang divine law ay matatagpuan sa Bible, sa Muslim, ang divine law matatagpuan sa Quran. Ano nga ba ang sanction ng hindi pagsunod sa divine law? The sanction of divine law lies in the assurance of certain rewards. So, kapag finulfill mo ang divine law, merong rewards. At kapag hindi mo sinunod, may punishments in the present life or in the life to come. Itong mga ito, nakalagay ito sa loob ng Bible at loob ng Quran kung ano-ano yung mga sanctions na yan. Second is natural law. Again, I have to emphasize, divine law is not promulgated by the state. Next is natural law. It is the law of nature or metaphysics. It is defined as the divine inspiration in man in the sense of justice, fairness, and righteousness, not by divine revelation or formal promulgation, but by internal dictates of reason alone. Itong natural law, ito yung law na innate sa tao. Hindi ito nanggaling sa kung saan, sa kung kanino na ini-enforce sa tao, kundi ito yung nanggagaling sa loob. It is the law of man, and sabi nga, in every man, there is a basic understanding of right and wrong, ng tama at mali, based on an understanding of the fundamental standard or criterion of good and evil. Sa madaling salita, may mga akto, may mga conduct na alam ng tao sa puso niya, a man knows in his heart and in his conscience, and not by theorizing, but by the dictates of his moral nature, are simply good or bad or evil. Hindi ito idinitikta sa tao, pero alam ng tao na ang isang bagay ay mali or tama, masama or mabuti. Thus, we know that killing for the sake of killing or stealing for the sake of stealing is bad or evil because it is contrary to what we believe is just, fair, or righteous. When we speak of this inward instinct of justice, fairness, and righteousness in man as divinely inspired by the dictates of his higher nature, we are talking about natural law or the law of nature. So, ito talaga yung innate sa tao. Na hindi mo kailangan sabihin sa tao na mali yan, pero alam niya because meron siyang natural law inside. Pagdating naman sa, kung ikukumpara natin siya sa divine law, medyo magkalapit sila, pero ang pinagkaiba nila, divine law, is made known to man by means of direct revelation. Ibinigay ng Diyos ang divine law sa tao. Sa kabilang banda, natural law is said to be impressed in man. Yun nga, nasa loob siya ng tao mismo, as the core of his higher self, at the very moment of being or perhaps even before that. So, ayun. Though natural law, hindi rin siya promulgated nor enforced by the state, pero it is regarded as the reasonable basis of state law. Kumbaga, yung state laws natin, marami nakabase sa natural law. So, ayun, proceed tayo sa moral law. Moral law naman, it is more concerned with the field of ethics. When we talk of moral law, We are speaking of the totality of the norms of good and right conduct growing out of the collective sense of right and wrong of every community. Ito yung pagkaalam sa mabuti at masama na hindi lang ikaw personally, kundi kayo as a community, nagkakaroon kayo ng common understanding na itong bagay na ito ay tama o mali. Paano nga ba na-determine kung ano ang tama at mali? Well, at a comparatively early stage of their existence, human beings learned that it was good for the welfare of the group that the privilege to determine what is right and what is wrong was not left to each member of the group. Hindi lang siya ibibigay mo sa bawat miyembro ng tao. Dito papasok yung collective sense nga ng right and wrong. The ways of life then evolved, which were always considered right and correct, and obedience to them was demanded by the group. With regard sa sanction, there is no definite legal sanction or punishment imposed by law like imprisonment or payment of penalties or fines for violation of purely moral law. Yung mga purely moral law, hindi siya pinapatawan ng state ng any punishment. But if a member of the community disregards the moral norms, a social reaction like public displeasure or contempt is produced. Sa kabilang banda naman, if there is conformity to the moral norms, a social response of approval or public pleasure is created. Moral law is not absolute, as it varies with the changing times, conditions, or convictions of the people. Pwedeng yung moral noon, nung unang panahon, ngayon hindi na siya moral. Depende sa, changing times, conditions, or convictions of the people. Halimbawa, polygamy and same-sex marriage, which are considered immoral in the Philippines, but is legal and allowed in some parts of the world. Magkaiba kasi yung moral law sa Philippines at sa ibang parte ng mundo. Kaya yung polygamy and same-sex marriage, hindi okay sa atin. But sa ibang parts ng mundo nga, pwede. Okay lang sa kanila yon base sa moral law nila. Another example is women's fashion, which are socially allowed, but at different times, they would have been morally condemned. So, epekto to ng changing times. Pwedeng noon, very, very condemned yung mga maiiksing damit, ganyan. But now, ito naman natin na it has become somehow acceptable na. Kung ikukumpara natin ang moral law sa state law, magkaiba sila pero to a great extent, moral law influences or shapes state law. May effect si moral law sa state law. Next is physical law. It is the law of physical science or physics. It is a law of physical science being addressed to objects which have no power to disobey. In reality, this is nothing more than an order or regularity in nature by which certain results follow certain causes. Ito yung mas involved ang science. Wala ditong rational thinking. Involved lang dito yung pagkakaroon ng order or regularity in nature. Kaya siya nagiging law. So, technically, law lang siya by analogy. It is called law by analogy. Analogy lang. Hindi siya talaga law. Ang examples nito ay mga law of gravitation, and law of chemical combination. So now, proceed tayo sa state law. Again, ito yung law in the strict legal sense. Again, we repeat that as a rule of action, only state law is promulgated and enforced by the state. Ito lang, hindi kasali yung divine law, moral law, physical law, and ano pa nga yung isa? Natural law. It is also called positive law. Other terms sa state law, positive law, municipal law, civil law, or imperative law. It is the law that we refer to when we speak of law in connection with obligations and contracts, marriage, the administration of justice, the conduct of elections, and the entire governmental process itself. With regard sa binding force ng state law is enforced by the state with the aid of its physical force if necessary. Yung field ng state law different from those of divine, natural, and moral law. State law does not concern itself with violations of the said rules of action unless they also constitute violations of its commands. Walang pakialam ang state law kung may ma-violate mang divine law, moral law, natural law, or physical law, unless itong violations na to ay committed as violations din ng state law. So, ayun. We proceed now with the concept or divisions of law. The term law, again, may be understood in two concepts. First is general or abstract sense, and the second is in the specific or material sense. First, in its general sense, it refers to all the laws taken together. It refers to the mass of obligatory rules established for the purpose of governing the relations of persons in society. Examples are law of the land, rule of law and not of men, equality before the law, enforcement of the law. Ito yung paggamit natin sa term na law in its generic sense. Pag sinabi nating law, without particularly referring to any specific law, ito yung tinutukoy natin, law in its general sense. Pag sinabi naman nating law in its specific sense, it refers to a rule of conduct, just, obligatory, promulgated by legitimate authority, and of common observance and benefit. Again, ito yung specific definition ng law. It is a rule of conduct, just, obligatory. Ibig sabihin ng obligatory, sinusunod ng lahat, obliged ang bawat isa na sundin, promulgated by legitimate authority. Ibig sabihin, promulgated siya ng state, any subdivision thereof, and of common observance and benefit. Importante itong definition ng law na ito. It refers to a particular statute or legal rule. Dito, itong law in its specific sense, dito papasok ang law on obligations and contracts. Specific na siya kasi binanggit na siya ay law specifically on obligations and contracts. Unlike kanina, napaka-generic. Pag sinabi nating law of the land, lahat yan ng law na meron ang Pilipinas. Equality before the law, malawak. Kung ano yung tinutukoy na law dito, broad siya. Kumpara dito, sa specific sense na may tinutukoy lang talagang law. At example nga, na particular sa topic natin is law on obligations and contracts. So, ayun. we proceed now sa characteristics of law. In its specific sense. We have to be specific na pagdating dito na we are talking now about law in its specific sense. Aalisan na natin, aalisin na natin sa eksena yung law in its general sense. Pero mahalaga na alam natin yung difference between law in its general sense and in specific sense. So, characteristics of law in meron tayong 4. It is a rule of conduct. It is obligatory, promulgated by legitimate authority, and it is of common observance and benefit. Ano ba pag sinabi nating rule of conduct? Ibig sabihin nito, it tells us what should be done and what shall not be done. As a rule of human conduct, law takes cognizance of external acts only. So, ayun, sinasabi bilang law as a rule of conduct, sinasabi nito sa atin kung ano ba yung dapat gawin at hindi pwedeng gawin. As, yun nga, as a rule of human conduct, yun lang mga ginagawa natin ang pwedeng pumasok dito. Yung mga innate sa loob, halimbawa yung mga nasa loob ng isip ko, nasa loob ng isip ng tao, hindi siya pasok dito. Kasi, hindi siya considered as conduct. Pangalawa, it is obligatory. Law is considered a positive command imposing a duty to obey and involving a sanction which forces obedience. Yun nga, hindi siya optional na sundin. Everyone in a nation, in a state, basta ikaw ay, halimbawa ikaw ay citizen of Philippines, kailangan mong sumunod. Hindi siya optional. Number 3, it is promulgated by legitimate authority. In a democratic country kagaya ng Pilipinas, the legitimate or competent authority is the legislature. In the Philippines, ang lawmaking body natin is the legislature. Under the Constitution, laws called statutes are enacted by Congress, which is the name of the legislative branch of our government. Local government units, kagaya ng city, province, municipality, barangay, are also empowered to enact ordinances which have the binding force of laws. So, yung laws natin, promulgated by the legislative branch of our government. Ang Congress ang nag-promulgate ng ating mga batas. Number 4, it is of common observance and benefit. Naturally, law is intended by man to serve man. Bakit nga ba may batas? Siyempre, mahalaga siya in order for, para magkaroon ng order sa isang society. Hindi naman siya ginawa ng tao para maging magulo yung sistema, kundi magkaroon ng maayos na sistema. It regulates the relations of men to maintain harmony in society and to make order and coexistence possible. Law must therefore be observed by all for the benefit of all. Imagine kung may law nga tayo pero yung iba lang yung sumusunod kasi hindi siya obligatory sa lahat. Hindi masaserve yung true purpose ng law, kundi which is to keep harmony in society and to make order and coexistence possible. So, ayun, pupunta naman tayo sa necessity and functions of law. Meron tayong 3 questions to answer. First, what would life be without law? Second, what does law do? Third, what is our duty as members of society? With regard sa first question, what would life be without law? If we can answer this question, we can answer the more basic question of whether law is necessary. If life without law would be the same as it is now, obviously law is not necessary. Society comes into existence because its members could not live without it. The need for internal order is as constant as the need for external defense. Walang society na magiging stable kung isa man sa mga requirements na to ay hindi nami-meet. So, talagang nandun yung necessity ng law para maging maayos ang existence ng society. Pangalawang tanong, what does law do? Settled tayo na law secures justice, resolves social conflict, orders society, protects interests, controls social relations. Madaming ginagawa ang law. Yun nga, secures justice. Meron tayong revised penal code, yung criminal law natin. Resolve social conflict. Meron tayong civil code. At marami pang other legislations na ipinasa ng Congress para makatulong sa social relations ng tao. Protects interests, controls social relations. Yan, pasok din yun sa civil code. Maging sa labor code, pwede rin. Life without basic laws against theft, violence, and destruction would be solitary, nasty, brutal, and brutish, and short. Life without other laws such as those regulating traffic, sanitation, employment, business, redress of harm, or of broken agreements, and many others, would be less orderly, less healthful, less wholesome. So ayun, maraming nagagawa ang law para sa society. Lastly, what is our duty as members of society? So, alam naman natin that no society can last and continue without means of social control, without rules of social order binding on its members. The sum of such rules as existing in a given society under whatever particular forms is what in common speech we understand by law. Since nakita natin na mahalaga ang law, each one of us, every citizen, should have some understanding of law and observe it for the common good. So, paano nga naman ba natin masusunod ang law kung hindi naman natin alam kung ano yung sinasabi ng batas? So, we are duty-bound as good citizens of this country to have some understanding of law and observe it para sa ikabubuti ng nakararami. Now we proceed with the sources of law. Meron tayong two classifications ng sources of law. First is primary and the other is secondary. Under primary, nandiyan ang constitution, legislations, yung mga batas. Third, administrative or executive orders and implementing rules and regulations. Fourth, judicial decisions or jurisprudence. Mention ko to before, jurisprudence. And custom. Isa-isahin natin. Constitution. Constitution may be defined as the written instrument by which the fundamental powers, pag sinabi natin fundamental powers, basic powers, main powers, necessary powers of the government are established. Doon daw ini-establish yung ating mga fundamental powers ng government. Emphasize natin, established. limited, and defined. And by which these powers are distributed among the several departments for their safe and useful exercise for the benefit of the people. Itong constitution, ito yung pinaka manual ng lahat ng sangay ng ating gobyerno. We have to know na yung mga batas natin cannot go against the Constitution. Any law or any ordinance na naipasa, hindi sila pwedeng maging contrary sa sinasabi ng Constitution. It is often referred to as the fundamental law or supreme law or highest law of the land because it is promulgated by the people themselves, binding on all individual citizens and all agencies of the government. It is the law to which all other laws enacted by the legislature, as well as administrative or executive acts, orders, and regulations having the force of law, must conform. Yun nga, walang batas or any other statutory enactment na pwedeng ipasa na nagva-violate sa Constitution. Pag ganun ng case, yung batas na yon or yung ordinance na yon void, invalid, wala siyang effect. Number 2, legislations. Ano bang ibig sabihin ng legislation? Legislation consists in the declaration of legal rules by a competent authority. Ito yung broad definition ng legislation. It is the preponderant source. Ibig sabihin ito yung main source of law in the Philippines. Acts passed by the legislature are so-called enacted law or statute law. Legislation includes ordinances enacted by local government units. So, dito papasok yung mga civil code, revised penal code, labor code, republic acts, and among others. Next naman ay administrative or executive orders and implementing rules and regulations. Itong administrative or executive orders and implementing rules and regulations or IRR, these are those issued by administrative officials under legislative authority. Administrative rules and regulations are intended to clarify or explain the law and carry into effect its general provisions. Administrative acts are valid only when they are not contrary to the laws and constitution. Itong administrative or executive orders and IRRs, per se, hindi ito mga batas. Pero these are created by the executive bodies in fulfillment or under their quasi-legislative power. Pag sinabi natin quasi-legislative power, di ba ang legislative body natin is the Congress, the upper and lower house. Technically, dapat sila lang yung gagawa ng batas. Pero since meron tayong mga executive bodies, halimbawa BIR, hindi siya legislative body. Hindi niya talaga trabaho ang gumawa ng batas. But since meron tayong mga batas na ginawa ng Congress, halimbawa NIRC, National Internal Revenue Code. Itong BIR, kailangan niya mag-formulate ngayon ng administrative rules, implementing rules and regulations para ma-implement ngayon yung mga batas na ginawa ng Congress, yun nga, NIRC. Ito yung tinutukoy na administrative or executive orders under the quasi-legislative power of this administrative agencies. Sa madaling sabi, hindi siya talaga legislative, pero since they serve as instruction sa citizens, society, kung ano yung dapat gawin, kaya siya ay quasi-legislative. More on that, medyo technical ito, kaya we will leave that sa mga susunod nating session para mas maintindihan natin. Medyo mahirap pa siya ngayon. Number 4, judicial decisions or jurisprudence. Yung decisions ng Supreme Court applying or interpreting the laws or the Constitution form part of the legal system of the Philippines. So, yung mga nakikita nyo sa Supreme Court reports na halimbawa People versus Juan de la Cruz, halimbawa BDO versus BPI pagdating sa civil cases. Itong mga cases na decided by the Supreme Court, ito yung tinatawag natin na jurisprudence. Sila ay they are part of the law of the land, since ito yung way ng ating judicial system to interpret kung ano talaga yung mga sinasabi ng batas. Kumbaga, ito yung mga pagpapaliwanag. Kaya siya ay primary source din ng law sa Pilipinas. Meron tayong tinatawag na doctrine of precedent or stare decisis. Ibig sabihin nito, the decisions of a superior court on a point of law are binding on all subordinate courts. Ibig sabihin din itong doctrine of precedent or stare decisis, once na-declare ng Supreme Court itong specific interpretation or explanation ng isang judicial controversy, ng isang halimbawa ng isang ambiguity sa isang batas, yun na yung magiging precedent, yun na yung magiging standard until and unless subsequently ibalik ta rin siya, i-overturn siya ng Supreme Court in a separate subsequent case. Pero yun nga, until and unless i-overturn siya, ay ibig sabihin ng overturn is palitan or mag-iba ng stand ang Supreme Court, yun ang susundin sa pagde-decide ng mga susunod pang kaso. Next ay custom. Custom consists of those habits and practices which through long and uninterrupted usage have become acknowledged and approved by society as binding rules of conduct. It has the force of law when recognized and enforced by the state. So, para magkaroon ng force of law ang isang custom, it has to be recognized and enforced by the state. For instance, in a contract for services rendered where no definite compensation is stipulated. Halimbawa, may kontrata na magre-render ng service si Mr. A, pero walang definite na amount ng salary or wage na nilagay. Yung bayad doon, yung ibabayad nung nag-contract ng service may be ascertained from customs and usages of the place. Ibabase mo siya sa kung anong nakagawian, kung ano ang custom doon sa lugar. A custom must be proved as a fact according to the rules of evidence. Itong custom, hindi mo lang siya pwedeng basta sabihin na, ito custom to. But, kailangan siyang i-prove sa court para siya ay makonsider talaga na custom as a primary source of law. Para i-acknowledge siya na meron siyang binding force kagaya ng batas. It may be applied by the courts in the absence of law or statute exactly applicable to the point in controversy. But customs which are contrary to law, public order, or public policy are not countenanced. Pwede siyang i-apply ng ating mga court kung walang law na talagang may apply sa isang particular na controversy or situation. Pero, customs cannot be contrary to law, public order, or public policy. Kasi hindi siya i-consider ng court as correct source of law. So again, our primary sources of law: constitution, legislations, administrative or executive orders and implementing rules and regulations, judicial decisions or jurisprudence, and custom. Sources of law: continuation, secondary. First, principles of justice and equity. Second, decisions of foreign tribunal, opinions of text writers, and religion. Well, tinawag ito na secondary sources kasi i-apply mo lang siya in the absence of the primary sources. So, kung halimbawa may legislation, may batas tungkol sa isang sa isang controversy, halimbawa, hindi ka gagamit nitong maalinman dito sa secondary sources of law, kundi i-apply mo lang yung legislation. Ginagamit lang tong secondary sources kapag walang primary source. Hindi ito, again, itong secondary sources, hindi sila binding sa courts. Hindi compelled ang ating courts na mag-render ng decisions na nakabase dito sa apat na ito, especially if there are primary sources of law. Yung primary sources of law talaga ang binding sa ating courts. Supplementary lang itong secondary sources. So, ayun. Paano nga ba kung may doubt sa interpretation or pag-a-apply ng batas? Our civil code provides that no judge or court shall decline to render judgment by reason of the silence, obscurity, or insufficiency of the laws. Ibig sabihin, hindi pwede na may legal controversy pero magde-decline si judge or yung court na mag-render ng judgment kasi walang batas na nag-a-apply doon. Diyan papasok yung secondary sources of law kasi palaging dapat may judgment. And in case of doubt in the interpretation, sa pag-interpret or pag-a-apply ng batas, palaging it is presumed that the lawmaking body intended right and justice to prevail. Right, yung tama, and makatarungan. Kung merong doubt sa interpretation and application, and hindi siya squarely na ma-provide ng legal ng law ng current laws natin, it is presumed that the lawmaking body yung ating Congress, intended right and justice to prevail. Palaging itong dalawa. Pero kung meron naman ng mga batas na na applicable, ay walang problema, yun ang i-apply. We have to take note na halimbawa, yung isang batas, it appears to you or to the judge na sobrang harsh, hindi niya na i-apply, hindi pwede yon. Bali, ang magiging recourse ng judge doon is to apply the law, and he has to make a report so that proper revision or amendment could be made dun sa batas. Pero hindi pa rin siya yung magda-draft or mag-create ng amendment, kundi isa-suggest na lang. Create lang siya ng report na itong batas na to, parang too harsh naman, ganyan. Pero no choice siya, kailangan niya yung i-apply kasi yun ang subsisting law. Meron tayong statement na courts sa Pilipinas, courts are not only courts of law but also courts of justice. Kung merong pagkakataon ang judge na i-apply ang batas na nandoon yung faced with a choice between a decision that will serve justice and another that will deny it because of a too strict interpretation of the law, courts must resolve in favor of the former, for the ultimate end of the law is justice. Kung meron daw batas na kapag i-apply mo yung strict interpretation, is magpe-prevail ang injustice, the judge should use liberal interpretation. Kung yung strict interpretation ay magre-result sa injustice. This is particularly true where what is at stake is the life, liberty, or property of an individual, and more so if he is poor or disadvantaged. Sabi nga ng doctrine of social justice, sa madaling sabi, ibig sabihin nun, those who are poor must have more in law. Those who are at disadvantaged status, they should have more in law. So we will now proceed with a quick discussion of the organization of Philippine courts. So we have two classes, the regular and special courts. Under the regular courts, nandyan ang Court of Appeals, regional trial courts, first level courts. Namely, the Metropolitan Trial Courts or METC, Municipal Trial Courts or MTC, Municipal Trial Courts in Cities or MTCC, and Municipal Circuit Trial Courts. Special courts include the Sandigan Bayan and Court of Appeals. At the top is the Supreme Court, whose head is the Chief Justice. Ito yung judiciary branch natin. Under the Constitution, the judicial power or the power to decide actual cases and controversies. Judicial power ang tawag dun sa power na mag-decide ng mga kaso, which involves the interpretation and application of laws is vested in one Supreme Court. Ito nga siya. Supreme Court. And in such lower courts as may be established by laws. Bale, itong lahat na lower courts, ito ay established ng legislations on the organization of courts. The judiciary, composed of the courts, is one of the three main divisions of power in our system of government. The other two ay legislative and executive branch. When we speak of regular courts, this pertain to the Court of Appeals, again, RTCs, sitting in the different provinces and cities, and first level courts, metropolitan trial courts in metropolitan areas established by law, municipal trial courts in cities not forming part of a metropolitan area, and in municipalities and municipal circuit trial courts in areas defined as municipal circuits. At pag sinabi nating municipal circuits, combination of municipalities. Sabihin, yung dalawang municipality, halimbawa, meron silang iisang municipal trial court. The Supreme Court, the Court of Appeals, and the regional trial courts are considered courts of general or superior jurisdiction. Next ay special courts. Itong special courts, these are created under our Constitution. Example, ang Sandigan Bayan, it is provided in the Constitution to be a special anti-graft court. It forms part of the judicial hierarchy together with the Court of Tax Appeals, a special tax court created by law on the same level as the Court of Appeals. And then, meron tayong tinatawag na quasi-judicial agencies. Nakita na naman natin yung term na quasi. Pag sinabi natin quasi, pwede natin siyang isipin as parang semi-judicial, parang ganyan. Parang judicial agency, ganyan. Because, meron siyang judicial power. Adjudicatory power, to be specific. May power siya to decide cases. Na yung mga cases na yun, yung expertise naman, belongs to their, to the executive body, kung saan sila belong. Ayun. Administrative bodies under the executive branch performing quasi-judicial functions. Examples ay National Labor Relations Commission, Securities and Exchange Commission, Land Transportation Franchising and Regulatory Board, Insurance Commission, and many others. Independent Constitutional Commissions, ito naman yung mga commissions na created by the Constitution. Civil Service Commission, Commission on Elections, and Commission on Audit. Lahat ito merong quasi-judicial power. May mga kaso na i-file sa kanila. Meron silang mga issues or controversies na nire-resolve kasi meron silang power to do so. Again, yun yung tinatawag natin na quasi-judicial power. Pero we have to take note that hindi sila part ng integrated judicial system. Part pa rin sila ng executive branch, but they perform quasi-judicial power. So, ayun. We proceed now to the classifications of law. Sa totoo, there are various methods of classifying law. Pero magfo-focus na lang tayo dito sa provided sa book. First, as to its purpose, classification of law according to its purpose. As to its subject matter, ayun, dalawa lang muna. First is as to its purpose, substantive law and adjective law. Pag sinabi natin substantive law, it is that portion of the body of law creating and defining rights and duties which may be either public or private in character. Itong substantive law, parang ito yung nagsasabi kung ano yung rights and duties ng tao or ng organizations or ng artificial persons. Ang obligations and contracts, law on obligations and contracts, isang example nitong substantive law. Mas maiintindihan natin kung anong substantive law kung i-contrast natin siya sa adjective law. Adjective law naman is that portion of the body of law prescribing the manner. Kung ito ay rights and duties, ito namang adjective law, it concerns itself with the manner, kung paano i-enforce itong substantive law, itong rights and duties. It is sometimes called remedial law or procedural law. This provision of law, which says that actions for the recovery of real property shall be filed with the RTC, yung daw provision ng batas na sinasabi na halimbawa itong kaso na ito na pertaining sa real property ay ifa-file mo sa RTC at hindi sa MTC ay isang adjective law or procedural law. We have to realize that rights and duties are useless unless they can be enforced. It is not enough, therefore, that the state regulates the rights and duties of all who are subject of the law. It must also provide legal remedies. Kailangan i-provide din ng batas yung legal remedies kung ano ba yung dapat gawin para ma-enforce itong rights and duties. Halimbawa, meron nga tayong nakaspecify sa batas na rights and duties pero wala namang nakalagay kung paano i-enforce, useless din. So, talagang kailangan din ng adjective law. These two should always go hand in hand. The adjective law or procedural law in the Philippines is governed by the rules of court. Tinatawag nating rules of court. And these rules of court ay promulgated ng Supreme Court by virtue of its rulemaking power. With regard naman sa ating as to its subject matter classification of law, we have public and private law. Pag sinabi nating public law, it is that body of legal rules which regulates the rights and duties arising from the relationship of the state to the people. So, may dalawang parties sa public law, state and the people. Kaya siya tinawag na public. Kasi ang other party ay the state. Example of public law is criminal law, law which defines crimes and provides for their punishment. Sa totoo lang, when a person commits a crime, he violates not only the right of the individual victim, but primarily that of the state because the crime disturbs the peace and order of the state. Halimbawa, si Mr. X ng rape. So, may offended party. Yung offended party, yung individual victim, siya yung magiging private complainant halimbawa sa isang criminal case. Pero sa totoo lang, offended party din ang state kasi na-violate yung peace and order na ine-aim na ma-maintain ng ating mga batas. So, nagkaroon ka rin talaga as an offender ng violation against the state. Pag sinabi naman nating private law, it is the body of rules which regulates the relations of individuals with one another for purely private ends. Ito ay people and people. Walang involved na state dito, kundi purely private relations between two natural persons or two one natural person and one artificial entity. Basta hindi involved dito ang state. Purely private ends ang sineserve nitong private law. Dito papasok ang law on obligations and contracts because it deals with the rights and obligations of the contracting parties only. The state, however, could also be involved in private law. It enforces private law but simply as an arbiter and not as a party. Taga-enforce lang ang state pagdating sa mga private laws, pero hindi siya party. Included also in private law are civil law, commercial or mercantile law, and civil procedure. Civil procedure is that branch of private law which provides for the means by which private rights may be enforced. So, ayun, we now go to the law on obligations and contracts defined. Papasok na tayo sa law on obligations and contracts. Medyo primer pa lang. It is defined as the body of rules which deals with the nature and sources of obligations and the rights and duties arising from agreements and the particular contracts. This law on obligations and contracts is found in RA number 386 or otherwise known as the Civil Code of the Philippines. By the way, when we speak of civil law, we refer to the law found primarily in our civil code. Pag sinabi natin civil law, ito yung mga batas na nasa loob ng civil code. Quick background, just some background about the Civil Code of the Philippines. It is based mainly on the Civil Code of Spain, which took effect in the Philippines on December 7, 1889. The Civil Code is divided into 4 books. Yung specific provisions on law on obligations and contracts can be found in Book 4 of the Civil Code. The general provisions on obligations are contained in Title 1, Articles 1156 to 1304, while those on contracts in Title 2, Articles 1305 to 1422. The general rules of law governing contracts are also applicable to the particular kinds of contracts like sale, agency, partnership, barter, in addition to the special provisions of law governing each type of contract. So, ayun. Punta naman tayo dito sa conclusive presumption of knowledge of law. Sabi sa Article 3 of the Civil Code, Ignorance of law excuses no one from compliance therewith. Napakahalagang concept nito. Napakahalagang standard nito pagdating sa ating civil society, sa ating civil code. Meron tong mga dahilan. Una, if laws will not be binding until they are actually known, then social life will be impossible because most laws cannot be enforced due to their being unknown to many. Second, it is almost impossible to prove the contrary when a person claims ignorance of the law. Totoo, napakahirap i-prove na alam ng isang tao ang isang batas kung kine-claim niya na hindi. Kaya kailangan itong presumption na ito na alam ng tao ang batas. Number 3, it is absurd to absolve those who do not know the law and increase the obligations of those who know it. And fourth, in our conscience we carry norms of right and wrong and a sense of duty, so that our reason indicates many times that we have to do, and in more complicated juridical relations, there are lawyers who should be consulted. Ibig sabihin kasi nitong ignorance of the law excuses no one from compliance therewith. Everyone is conclusively presumed. Pag sinabi nating conclusively presumed, hindi mo siya pwedeng i-rebut. Hindi mo siya pwedeng pasinungalingan. Hindi ka pwedeng mag-introduce ng evidence para ma-counter yung bagay na yon. So that good faith and ignorance thereof, ignorance ng batas, cannot be invoked as a valid defense in case of violation. Hindi pwedeng halimbawa, ako, may kinuha ako na, halimbawa may nakita akong cellphone sa ibabaw ng table. Kinuha ko. Pero hindi siya akin. At tapos nahuli ako. Hindi ko pwedeng sabihin na, ay, hindi ko naman alam na bawal kunin yung bagay na hindi akin para ma-excuse ako dun sa ginawa kong crime. Kasi, meron tayong provided sa ating criminal law, sa revised penal code, about theft, about stealing. So, kahit, halimbawa, technically, hindi ko talaga alam yung provision ng batas na yon. Hindi ko pwedeng sabihin na dahil hindi ko alam, hindi ako pwedeng parusahan. Kasi nga, meron tayong provision na ganito, ignorance of law excuses no one from compliance therewith. Ina-assume ng batas, ina-assume ng ating state na alam mo ang lahat ng batas. Pero alam naman natin technically na that's impossible. Not really impossible, but medyo unrealistic. But kailangan siya, itong concept na to, kailangan siyang i-apply kasi necessary siya so that justice and order is maintained. This rule proceeds from the requirement that all laws shall be published in the official gazette 15 days before its date of effectivity. With all fairness naman sa ating manner of publishing, manner of distributing these laws, yung para maipaalam sa mga tao na, na meron ganitong batas, it is a requirement that lahat ng batas ipapublish sa Official Gazette 15 days before its date of effectivity. Without compliance dito sa requirement na to, without publication, ang isang batas ay hindi mo masasabi na valid or effective. Kung walang publication, hindi mo pwedeng sabihin sa tao na hindi mo pwedeng sabihin sa tao, sa citizens na covered na sila ng batas na yun, na bound na sila ng batas na yun. Kailangan mo muna silang bigyan ng notice. Ito yung pinaka nagiging notice sa tao na, uy, merong ganito ng batas, so you have to comply. Without this publication requirement, hanggat hindi napapublish sa general public itong new law or new ordinance, hindi siya magiging valid and effective. So, ayan. Meron pa pala tayong last importance of this concept. Sabi ni De Leon, evasion of the law would be facilitated. Napakadali daw takasan ng batas, and the administration of justice would be defeated if persons could successfully plead ignorance of the law to escape the legal consequences of their acts or to excuse non-performance of their legal duties. The rule, therefore, is dictated not only by expediency but also by necessity. Ayun nga, hindi lang siya maganda, pero talagang kailangan itong concept na ito. Kasi ang dali nga namang idahilan na halimbawa, na kapag commit ako ng ganitong crime, pero ang defense ko, hindi ko alam na crime yan. So, talagang napaka-facilitative nitong, napaka-helpful nitong concept na ito sa administration ng justice. Halimbawa, ignorance of the provisions of the law imposing a penalty for illegal possession of firearms or punishing the possession of prohibited drugs does not constitute a valid excuse for their violation. Halimbawa, sabihin ng possessor ng illegal possessor ng firearm na hindi ko naman alam na bawal magdala ng firearm, ng barrel, ng walang permit, ng walang license to carry. Tapos o kaya halimbawa sabihin ng isang drug user na hindi ko naman alam na bawal gumamit ng drugs, ng illegal drugs, ganyan. Hindi yun magiging excuse ever for their violation because of this Article 3 of the Civil Code. We have to always remember that ignorance of law excuses no one from compliance therewith. At isa rin itong dahilan kung bakit nga natin inaaral ang law on obligations and contracts. Hindi rin natin pwedeng sabihin in the future na halimbawa, nag-enter tayo sa contract, tapos meron pala doon na violate tayo, or meron pala doon na against any law, any commercial law or civil law. Tapos sasabihin natin, hindi ko naman alam, ganyan. Hindi siya uubra because meron tayong ganitong standard na hindi pwedeng gawing excuse yung ignorance ng isang batas sa pag-comply doon. So, ayun, doon na muna nagtatapos ang ating discussion for law on obligations